Our first panel today is discussing the issue of Africa and the ICC, misperceptions and realities. Without too much of an introduction, Dr. Kersten from the Munk School of Global Affairs, University of Toronto, Research Director, Wayamo, will introduce firstly our speaker and representative of AGJA on this one for introductory remarks, and then introduce the panelists.
Well, thank you very much. It's a great privilege for me to be here, and I'm very excited to moderate a panel discussion on the relationship between Africa and the International Criminal Court, an issue which clearly goes to the very heart of international criminal justice and which may very well determine the future of the International Criminal Court. Before we have a panel conversation and a discussion about this, I do want to first welcome Richard Goldstone, former Chief Prosecutor of the UN Tribunals for the former Yugoslavia, as well as Rwanda, to give some opening remarks on behalf of the Africa Group for Justice and Accountability. Richard.
Thank you very much, Mark. Good morning, everybody, and I would like, on behalf of the group, to add my thanks to Her Excellency, the Swiss Ambassador, for her remarks, and particularly for the support that this group is getting from the Swiss government. Misperceptions and realities about the International Criminal Court. I suggest there are too many misperceptions and too little attention given to the realities. The debate about the International Criminal Court has become very adversarial. Many things around the world, if one looks at American politics today, we can see how adversarial situations have become and how the middle begins to disappear and in many respects has disappeared. And I think the same is true of much of the debate around the International Criminal Court. Both sides are talking past each other in many cases. Some of the realities are that 2/3 of the countries of Africa have ratified their own statute, and I suggest really nothing fundamental has changed since those ratifications in the 90s. And in the late 90s and early 20s. The change that has taken place is the number of African leaders who seek to protect themselves and their friends from any question of investigation from outside their countries. And the more autocratic the leaders are, the more concerned they are to protect themselves. I need hardly remind many people in this audience that of the 9 situations presently before the court, 5 have been referred by African governments, 2 have been referred by the Security Council, and 2 have been initiated by the Prosecutor. A 10th situation is now being investigated, as we heard from President Fernandez, namely Georgia, the first in Europe, and the first involving potentially a member of the Permanent 5 of the Security Council, the Russian Federation. Clearly there are many possible developments arising from that. The major problem for the court is that, generally speaking, powerful nations and their friends are protected from the court's jurisdiction. Sri Lanka and Syria come immediately to mind. That they should be investigated by the International Criminal Court goes without saying. But it is that partiality and that exceptionalism that leads to justifiable allegations of uneven and unfair international criminal justice. This is not a new problem. Let me briefly give you one personal example. Soon after I became the Chief Prosecutor of the Yugoslavia Tribunal, I decided to pay courtesy visits on the 3 governments of the former Yugoslavia. And my first meeting was with the Minister of Justice of Serbia. We were supposed to meet for half an hour, but he spent the first 45 minutes giving me his history of the former Yugoslavia. It was accurate but partial. I heard the Serb version, but I didn't hear the versions from the side of either Croatia or Bosnia and Herzegovina. And then he said to me, I think it's highly unfair, and Serbia and the former Yugoslavia is being treated unfairly by the international community. And I said, Minister, why do you say that? And he said, well, why is the first International Criminal Court for the former Yugoslavia? He said it wasn't set up for Pol Pot, who committed much worse crimes than have been even alleged in the former Yugoslavia. It wasn't set up for Saddam Hussein, who used chemical weapons against his own Kurdish population. Why Yugoslavia? And I said, Minister, I hear you, and all I can say is if Yugoslavia is not only the first but also the last, you have every reason to complain. It would be an act of partiality and bias. And I said with my heart in my mouth, I said, but if others follow, you don't have any real reason to complain about being the first. Little did I know that very shortly down the road there'd be a Rwanda tribunal and a Sierra Leone tribunal, and that not too far down the road there would be an international criminal court. But his complaint mirrors some of the complaints one hears from Africa. There's this unevenness which is unacceptable. If there's international justice, it should be across the board. It should be, as President Fernandez suggested, it should be universal. The opposition in the African context comes primarily from the elite, not from the victims. And it's the victims who are forgotten and drop off the table, certainly at high-level meetings. The situation in Kenya amply demonstrates that leaders are concerned for their own protection and do not take into account the interests of the many tens of thousands of victims in their society. Then, of course, there's the problem of some governments using the court for their own political advantage and for their own political reasons. And some governments, such as Uganda, immediately come to mind, wanting to switch on and switch off international justice depending on the politics of the day or the month. When Kenya had the opportunity of avoiding the jurisdiction of the ICC by exercising its rights of complementarity, it didn't. The Kenyan Parliament failed to pass any legislation to investigate the allegations made against some of their leaders in the 2007 election. One provocative point I would throw out. I believe that the ICC made a fundamental error in not arresting and putting in the prison the Kenyatta and Ruto and the other Kenyan leaders who voluntarily handed themselves over. In the Yugoslavia tribunal, 10 senior Croatian generals handed themselves over for trial. There was never any suggestion that they shouldn't wait their trial in the prison of the tribunal. People charged with crimes at the level that there's jurisdiction in the ICC shouldn't be allowed to roam around free. It may well be that there would have been repercussions, and it may well be that Kenyatta and Ruto wouldn't be president and deputy president of Kenya, because at the time they handed themselves over, they weren't. And it's inappropriate that people against whom are pending crimes at that level should become leaders of their community. There's no way that those Croatian generals would have been released from the custody of the court by the judges of the Yugoslavia tribunal, and there's no way that my successor as prosecutor, Luis Arbor, would have agreed to them being released on their own recognizances and expected to come backwards and forwards and deal with their business at home. So this is something I think that deserves attention and has been pretty much ignored. The changes in the South African attitude, of course, as a South African, are extremely worrying. The change between May 2009, when President al-Bashir was told he couldn't come to the inauguration of President Zuma because he would be arrested and transferred for trial to the International Criminal Court, the change between that and the unfortunate position in June 2015. That change was, of course, referred to in fairly vivid terms in the majority judgment in the Supreme Court of Appeal last week. Lastly, the question has been raised about an African court to try these crimes rather than the ICC. In principle, I don't believe there can be any objection to that. Be completely consistent with the Rome Treaty and complementarity to have regional courts with jurisdiction. And the issue is whether there's a political will and the economic situation allows for such a court to be created. But again, this is something that should be welcomed. Any form of justice and withdrawal of accountability, withdrawal of impunity, certainly should be supported with open arms by all those in favour of international criminal justice. So I think I've referred to just a few of the issues that I'm sure are going to be raised by members of the panel. And I look forward very much to hearing from the really wonderful expert that we have on my left. Thank you very much.
Thank you very much, Richard, for those candid and important remarks. I think they go to the core of a lot of the issues that hopefully we'll discuss on this panel. I don't think we could have much of a better panel or even a better panel to discuss this relationship between Africa and the ICC. So I'll just very briefly introduce our panelists. We have Elizabeth Evanson, who's Senior Counsel in the International Justice Program at Human Rights Watch. We have Jim Goldstone, the Executive Director of the Open Society Justice Initiative, Charles Jallow, Associate Professor at Florida International University College, as he mentioned previously. Bill Pace, the convener of the Coalition of the International Criminal Court, who has also introduced himself already today. And finally, Tim Murithi, the head of the Justice and Reconciliation in Africa program at the Institute for Justice and Reconciliation here in Cape Town. This will be more of a moderated conversation rather than a panel with statements, and then followed, hopefully, if we have time, for some questions and answers from the audience. So I think we'll get started. And so, Tim, if I can ask you, what is, in your view, the single biggest issue driving or defining the relationship right now between Africa and the International Criminal Court?
Thank you very much, Mark and the Wayamo Foundation, for this invitation, particularly Bettina, who hunted me down on what are school holidays here in Cape Town. And I had to explain to my 3-year-old daughter where I was headed, and it was not an easy thing to pull off. Mark, very important point. I come from the intersection between international criminal law and peacebuilding, which perhaps I think that the majority of the people in this room are less familiar with peacebuilding than they are with ICL, ICJ. The AU's engagement with this issue, I think, goes way back to 2000. The founding document of the African Union, the Constitutive Act of the AU, speaks to the issue of impunity, which was a whole 2 years before the Rome Statute came into effect. African Union member states have undergone a number of processes, democratic transitions. So I think in the framing, firstly, when we frame the issue as it's framed in the program, to refer to the AU as a club of dictators might actually miss the mark almost entirely. You speak of Tanzania, Ghana, Botswana, we have the Attorney General here, Mozambique, Senegal. So I think we need to frame these issues more cautiously if we want to have this dialogue that the Swiss ambassador spoke of. The AU became engaged not shortly after the Sudanese referral by the Security Council, when it appeared that obviously the president of Sudan might be in the situation of having to in fact go to The Hague to account for his war crimes. Everything Judge Goldstone has said is true. In terms of the desire by African heads of state to protect themselves and to prevent themselves from being prosecuted. So at least the first issue is immunity for heads of state, which I think the majority of people in this room are familiar with. The optics of Lubanga and Daganda now Bemba ruling, in fact, exacerbates that fear amongst the heads of state. It's not going to get better, it's going to get worse. So anticipate some kind of movement from the AU. The second issue is sequencing of peacebuilding and international criminal justice, which I will speak to a little bit. And the third is the geopolitics, the United Nations Security Council factor, which the president of the ICC spoke to. but I think we need much more nuance than what came through in that presentation. Very, very quickly, there are 4 prisms that you can use to look at the issue of accountability. And this is based on the work that we do at the Institute. Mass atrocities, there is a need, when you have mass atrocities, there's a need for redress, restoration of societies that have endured violent conflict and authoritarianism. The 4 prisms you can use to look at this issue of mass atrocities: the legal prism, the political prism, the peacebuilding prism, and the moral ethical prism. And I think that's extremely important in terms of framing. The reason why both supporters of the ICC are speaking in one direction and heading in a different direction, and AU politicians, peace builders are speaking and heading in a different direction, is I think because we do not have a sufficiently nuanced understanding of these 4 prisms. Mark, and I'm going to very quickly, the legal prism I don't need to explain. The people in this room are very familiar with, legal practitioners, analysts, scholars, judges. The political prism, this is the Machiavellian corruption of institutional processes. I don't need to explain that because it's also been discussed by the judge. The peace-building prism is much more complicated and very important to actually unpack slightly. And the moral and ethical I'm not going to go into because that's for our philosophers. We don't have that many philosophers in the room. But very quickly on the peace and justice dilemma, which is often put up as a dilemma, but nobody really explains how you're going to resolve it. Even the review conference of the Rome Statute in Uganda pretty much just fudged that whole issue. It just said, oh, peace is very important, justice is very important, that's it. You've heard of the adage, no peace, no justice. That is absolutely true. The converse is also true, no justice, no peace. Now, the issue really is which order you place those two. These are 2 universal truths. The only thing that really separates the large majority of people in this room, legally trained, legally indoctrinated students of law, lawyers, judges, legal scholars, the only thing that separates you from the peace-trained and the peace-indoctrinated students of peace, peace builders, mediators, peace scholars, is the order in which you place these 2 co-joined universal truths. If I may generalize for a moment, our lawyerly fraternity, sorority, let me be gender sensitive, believe that justice should take precedence at all times. They struggle, though, to coherently explain how the single pursuit of prosecutorial, punitive, retributive justice helps a victim, a woman or a man, to achieve, or a community, to achieve inner positive peace, as well as the outer negative peace. And I think for the majority of lawyers, this notion of positive and negative peace is an alien concept. It's not taught. It really is not taught. And I would be grateful that if this could become one way that we approach our teaching of law. Equally, the Latin phrases proprio mutu, ius punendi are alien concepts to peace builders, but very familiar to lawyers. I think once we've understood this nuanced issue, right, I think then we might be able to actually have a dialogue. So prosecuting the warlord is not necessarily always the most appropriate course of action in every given situation. And I think equally trying to promote impunity is not equally appropriate. Now, the African Union has deployed that argument of the peace and justice nexus, but it has been dismissed out of hand, at least by the ICC member states system fraternity, as simply a cover, a camouflage to protect these heads of state that we said that are very keen to protect themselves. 1 minute to go. So for me, just very quickly, I'm going to even hit the Rome Statutes makes reference to the word peace once and doesn't really expand on it. Now, that's an issue that I think the whole ICC system, Assembly of States, the entire system needs to actually work to help us understand what this thing peace is that they refer to. The copt-out is to say peace building is for those guys. We only do international criminal justice here. And that's very easy cop-out. Unfortunately, doing international criminal justice in very volatile war situations can in fact exacerbate situations and lead to future deaths. That's something to think about. legal judicial action can in fact lead to future deaths, which is something that I believe, unfortunately, we don't consider closely enough. So I have expanded on the issue of the peace and justice. The geopolitics, I think, has already come out, but I can pick that up in discussion later on, Mark, because I think it's much more serious than we think. I think the president of the ICC spoke about the Security Council being the only instrument to bring other cases, but in fact the Security Council is the problem. I think it short circuits the Rome Statute through Article 16, and unless and until you either A, remove the Security Council from the Rome Statute, or B, transform the entire system of global governance, which is something the legal minds here should be thinking about doing. Unless we actually look at that as a valid and a viable project going forward, then we will be going around in these circles. There will never be any consensus. It's easy to dismiss that the need for that reform of that global system of governance because it's so difficult, because the permanent five will prevent you from doing it. They will deploy all of their diplomatic, military, political means to prevent you from changing that system. But we are in a country here where, in fact, there was a system, an oppressive system, that also refused to change itself. But it did come about. So just believe that that's possible, and let us apply our legal minds, our peace-building minds, into how we can change this system so that the project of international criminal justice, which I believe is the first step in a much larger project of changing the international global system, can actually go forward. Otherwise, we will speak around in circles, and the African Union is going to come with some agenda now, following the ruling of Bemba yesterday, and you will see the continued division. Mark, I'll just stop there.
Thank you very much. Charles, I want to ask you, Tim spoke obviously about UN Security Council referrals and also head of state immunity. Of course, the Security Council has referred to situations. In both situations, a head of state was targeted by the ICC for prosecution, effects on peace. Could you expand? Do you agree that the UN Security Council is a central problem in this relationship between Africa and the International Criminal Court?
First of all, thank you to Wayamo for inviting me. Tim, I think, has raised a number of important questions, and I think the focus on the Security Council is probably appropriate, because I would probably go a little bit further than he has to suggest that the Africa ICC problem may be more an Africa UN Security Council problem. And here's the reason why I say that. I think under the best of circumstances, we have seen with the experience of the ad hoc tribunals, and Richard, I think, laid it out very well, face incredible pushback, and he gave the example of Serbia and the selectivity argument being raised there. You could have gone further and mentioned Rwanda and the arguments of selectivity raised there. You could go further to Sierra Leone and raise questions there about the threshold of jurisdiction over those bearing greatest responsibility that actually had the effect of limiting the jurisdiction so much that there is a fundamental question of how much justice was actually achieved in light of the reality that no domestic prosecutions have happened. Now, of course, that's all complicated. We could talk about amnesties and Lome and all of that. But I want to suggest that the landscape in which the ICC was entering into now as a permanent institution is not one without the difficulties that Richard pointed to. Now, the layer that I find particularly problematic, for at least from the point of view of what we've been hearing from African states, Mark, is the role of the Security Council. And that is fundamental for at least two reasons. I mean, the key one, of course, is the legitimacy, right? A system of law, and it goes back to Richard, a system of law ought to be justified on principle. So the principle of equality of individuals as well as states. This is the starting point of international law. This is what the Charter is about. It's not about power, it's about principle. So once we accept that as a starting point, then the next step becomes, okay, well, how do you, in a system like that, where you carve out some exceptions for powerful states, how do you then deploy justice? Well, when we're designing the UN Charter in 1945, we were really not thinking about international criminal justice as a fundamental principle. We did start, I think, in 1948 with the Genocide Convention and so on, and we all know we eventually got the court a little bit belatedly, but at least it's here. The difficulty, of course, that legal principle now stands in tension with an institution that is highly political, and Judge Gumendi referred to that, and I really applaud her for accepting that this is a big challenge for the court. And I applaud the court for taking it up publicly in the sense of raising it both in terms of the benefits for the court, in terms of reopening the jurisdiction. But I would want to go a little bit to the other side and say maybe the court could be bolder. And here I want to pick up on 2 points that are actually embedded in the referrals. So in a sense, we were talking in the break about getting a gift that you appreciate so much. And this is the story that Mark can probably tell better than I. But essentially I was saying, apparently the view was, well, this is a gift to the court because they expand the jurisdiction, and of course there's so much need for justice, and I think that's important. The flip side of that, what is in the gift? Right? You don't want to complain about the wrapping, but when you open the gift, there could be things in there that you don't like. And the referral came with at least 2 difficulties. One, the council is not the primus inter pares in the same way it has a relationship with the Yugoslav Tribunal and the Rwanda tribunals, where it's the body that creates the tribunal, so in a sense it can direct them. The Rome Statute is an independent system, and it was meant to avoid creating ad hoc, so the council was supposed, when the United Nations will send work to the court, it's supposed to pay for it. Article 115 of the statute, they didn't want to pay, and we know politically why. I think part of the objection, of course, is the US. The US could not contribute to something like that because of the law that the US has. That's one. Second point, you then send the referral in and impose obligations of cooperation only on the referred state. So Sudan, you have a duty to cooperate. Libya, you have a duty to cooperate. Everybody else, we urge you to do so. The suggestion by academics, and Bill Shabas has been good about this, is to say, well, we know why too. And unfortunately, the finger goes back to my country, the United States, right? So there is, of course, a US objection for non-party states. I mean, we know that going back to the negotiation. So in a sense, to build on the concern about this and the legitimacy part of it, I would want the court to perhaps be in a situation where you could say, well, what is in the gift? Let's look at this a little bit carefully, because in terms of finding solutions, it undermines the court's credibility significantly when the court is seen from the part of the world, the developing world, the bulk of the world that doesn't sit on the P5, as then being embedded in a system that is actually unacceptable for legal principles. That is the principle of equality of states as well as of individuals before the law. That is, I'm going to suggest, a big challenge for the court, and we have to get past it. It's going to be, yes, about universality and expanding the jurisdiction, but it's about calling out, using the statute, that this is not a proper referral, that this referral has problems. Why don't we engage in discussions about when the check is going to come? Because we don't like the referral without the check. Because, of course, we know Madame Bensouda has been complaining all the time, both about the lack of money that comes with the referrals and also the follow-up that the council has failed to do in terms of calling out, many, many years after Darfur and the indictments of al-Bashir, no cooperation is forthcoming. And she's basically been complaining and complaining until the point she's more or less throwing her hands up in the air. And in a sense, if you count it against the court, I think it's a bit unfair on the court, but you got to count it against the council. And I think the court ought to hold the council accountable to some extent, to the extent within its mandate under the law, which is judicial decisions. In the same way it's calling out, it calls on, and there are, of course, political pressures that could be brought to bear. I think Liechtenstein, for example, is kind of making a movement in New York. Guatemala was very sound some time ago. Argentina, when the referral came, the discussion about Syria, Argentina was very strong to say, no, we got to be principled institutions. So the supporters of the court ought to step up. The states, the civil society, but also the court itself. And I'll leave it at that. If you want to pick up anything, I'm happy to develop it. But I think it's a big issue, at least from the point of view of the developing world. And I will go so far as to say, as my final point, that if you shifted the dynamic and took the African situation, Judge Gomendi suggested if this happened in the 70s, we had a court, it would be about Latin America. I would be very curious to see if you took the same problems and took them to Asia, that the council pushback would not happen there. I'll be very curious if other parts of the world came under the same spotlight, if in the same scenario, where they would not push back at this exceptionalism of the council. We got to raise that because, in a sense, it's a fundamental challenge for the system that we're trying to build.
Thanks so much. It's clear, it seems clear from your remarks that this relationship between the Security Council and the ICC is a real issue with regards to the court's relationship then with African states and different African constituencies. But one of the interesting things, and Liz, I wonder if you could speak to this, is that sometimes the relationship is said to have non-real things, right? So Tim kind of spoke to framing and language, and there seems to be misperceptions. And so just a couple of weeks ago, we heard that at the African Union in Addis, that there would be this roadmap to withdraw from the ICC. And your colleague at Human Rights Watch then wrote a good piece which said that actually never really happened. So I wonder, I mean, are these threats, in your view, real? These threats to withdraw, are they actually real? Or is it really bluster?
Well, thanks, Mark, and also let me just add my thanks to the university, to Wayamo, and to the Africa Group for having us here and making this discussion possible. I'm going to answer your question, but I just wanted to take a step back to maybe explain the context for the piece that you mentioned by my colleague, because I think it does illustrate one of the roles that civil society has been trying to play in this discussion about the relationship between the ICC and African states. And so what you were referring to was that during the AU summit, some of the media reporting immediately after the summit was that the African Union had voted to leave. So not the roadmap issue actually, but that they had actually voted to leave. And this was information that was being promoted by the government of Kenya. And so my colleague, but also other civil society groups that have been very active in an informal group over the last, say, 6-7 years as these issues have emerged, one of the roles we've seen is to work together to try to provide information, to correct misreporting, to correct misperceptions as and when we see them. And we've done this as individual organizations. We've also done it together in different statements. So this was an occasion where we had the sense that that was not actually what had happened, that there needed to be a moment to step back to see what the actual reality was. And I think that we were collectively successful, again, not only Human Rights Watch, but other groups that have been involved in this effort at getting that to reporters, getting that to journalists, and getting them to ask the questions of what actually was agreed on the floor. So that's been a very important role, I think, for civil society, and one that we need to continue playing. But in terms of what did happen, we now know, because at least there's a draft text of the final decision, we now know that there is a provision to come up with a strategy for engagement with the ICC, which includes possible withdrawal. Again, far different than what was reported right in the thick of things back at the end of January. In terms of whether that is bluster or whether that is real, well, one thing we know about that is that this language was proposed pretty late in the discussions at the African Union Summit. So I think it's probably correct to say that this text, this decision, does not necessarily represent the views of all members of the African Union, as we sit here today. It's also tempting to say, well, we've been here before. We all remember the extraordinary summit in 2013, where again, there was a sense that this could lead to a decision for mass withdrawal, that we could see a real break between the continent and the court. And that didn't happen. And it's also, I think, tempting to look at some statements, even since the African Union Summit, from governments like Tanzania, from Ghana, that they consider themselves to be, important members of the ICC. So you can look at all of this, but it's a little bit like reading tea leaves. And I don't think that we should be complacent. I don't know the answer to your question, whether it's real or whether it's bluster, but I think experience of watching these dynamics over the last 6-7 years in this relationship between the African Union and the ICC, we've seen that every time it looks like maybe there would be a way to bridge those gaps, to repair, to rebuild, to come to a common understanding and consensus again about the importance of the ICC, there have been setbacks. So I think, again, you can look and you can parse it, you can think about different countries, and you can really question why would they have an interest in withdrawing from the ICC, countries that continue to cooperate with the court, that have asked the court to investigate, that cooperate with other investigations. But I think overall, it's a situation where we should not be complacent. We should treat it seriously. And it makes the kind of engagement that I think both Tim and Charles have been talking about all the more important.
Great, thank you. I think it's quite clear that it's a very reactive debate, and oftentimes an explosive one, very much in the now, that we react constantly to developments. But I wonder, Jim, on this issue, are there maybe things from history or from the past that can help us understand the ICC-Africa relationship as it exists now?
Thank you, Mark, and let me just add my thanks to Wayamo and the university and the organizers of this event for the privilege of being here. In respect of history, of course, we heard Richard Goldstone speak of the history of the Yugoslav Tribunal, and I think it is instructive that to look back at some of the experiences of prior proceedings with respect to international accountability and the extent to which they have attracted some of the same kinds of arguments of selectivity and bias that one hears so prominently today with regard to the International Criminal Court. Even the very much lauded Nuremberg and Tokyo processes were characterized then and have since been as victor's justice. We've heard, of course, that with regard to the Yugoslav Tribunal, each of the communities at issue felt that it was being unfairly singled out, or others were not being given sufficient attention. In fact, there were also arguments by a number of folks that Western forces, the NATO bombing in Serbia, did not receive the attention that it should have. In the Rwanda process, we've heard the arguments about partiality and selectivity on all sides. In the Cambodia Tribunal, of course, there, the extraordinary chambers, a big question is why only focus, of course, on the horrific actions of the Khmer Rouge, but what about United States, what about China, etc. And I think, these tell us a couple of things. One, that are reflective and are instructive about what is happening today with regard to the International Criminal Court. One is that some of these criticisms are often made by leaders themselves who are targeted by these courts, or others who fear they will be. They are entirely the predictable, self-interested criticisms of people who are bearing the burden of being held to account for the crimes that they perpetrated. And I think that is very much today something we see in examples of who are prominent voices in the discussion in respect of Africa and the International Criminal Court. We can't avoid seeing that some of these voices, in fact, are people who themselves are charged, or people who are defending them, or who fear that they will be held to account one day by the International Criminal Court. But a second, I think, insight from this prior experience as well may be that some of the criticisms are not entirely unfounded, as we're hearing today on the panel and in this discussion. And some of the people, it's not always people who are self-interested and really lack legitimacy in making their opinions known. In fact, some of the people who are raising concerns about the operations of the ICC, I think it's a hard thing to acknowledge, but I think it is true, are some of the most courageous human rights actors around this continent and elsewhere, some of whom were involved in efforts at great risk to themselves to secure ratification of the Rome Statute in their own countries. Now that is a reality, and it reflects the fact that, as we've heard this morning, it's not news, but I think it sometimes doesn't maybe get the attention and weight that it needs, that yes, the ICC is, through no fault of the very capable people acting there today, but the Rome Statute system embeds the Security Council, this deeply political organ, as we've heard, in the process of selection of cases in a very controversial way. And the inequality of the fact that 3 P5 members have refused to subject themselves to that jurisdiction, while they have an opportunity to effectively affect the court's docket, that is fundamental, and that is being felt by many, many people. And then we've also heard questions about the way the court is operating. And again, that's no secret. Court officials here and in other circumstances recognize they're trying their best and they're trying to do better. And it is a fact that there is room for improvement in respect to the quality of investigations. There is room for improvement in respect to the expeditiousness of proceedings. There is a room for improvement in the way that the court interacts with victims and affected communities. So we acknowledge there are real challenges that we've heard. So I think, as in prior situations, there are some of the critiques are simply an indication the court is doing its job. Some of the critiques are an indication that there is more to be done. And then finally, I guess I would say, if you look at recent history, a third insight might be that Africa does not hold a monopoly on the allegations of ICC bias even today, right? I mean, if you go, you've heard harsh criticisms of the ICC in Washington, in Moscow, in Tel Aviv, in some other capitals that are not on the African continent, nor does Africa hold a monopoly on inconsistency, what some have said it might be hypocrisy about the concept of accountability. Just very recently, the government of Rwanda announced that on the eve of a scheduled hearing before the African Court of Human and People's Rights, that it was going to withdraw its declaration that subjected its government to individual communications to that body in a case that was deeply sensitive. Now that gave rise to concerns that, well, maybe the question is not so much foreign justice or Western justice or imperialist justice, but just any justice. But similarly, we've also have to see, and the President herself said this morning, the Rome Statute is a system. It's not just a court, right? And people view what the ICC does in a far broader context. And therefore, I think it's relevant as well that we've seen similar inconsistent actions in the global north. So when prominent figures in the United Kingdom threaten to leave the European Court of Human Rights because they disagree with its rulings, even as they admonish other states to heed the ICC court rulings that they don't like, that kind of duplicity helps fuel the argument of critics that double standards are at work. So I think history tells us that one must be careful in distinguishing different threads of criticism, recognizing that some are entirely the predictable result of what the court is doing. They need to be called out as such. Others, which I think actually merit reflection and perhaps some improvement on the part of the court, states, and civil society actors, which I hope we can get to later. Thank you.
Thanks very much, Jim. Also, maybe looking back a little bit, I think everybody remembers the relationship, the very difficult relationship between the United States and the International Criminal Court. And I wonder, Bill, because that relationship started to get better in the mid-2000s at almost exactly the same time as the relationship with African states and African constituencies started to get worse. Is that purely coincidental, or is the relationship between the increasingly close relationship between the ICC and a major power non-member state perhaps an explanation or part of the equation as to why certain African constituencies might be disappointed with the court?
Thank you very much. I think the quick answer is that the United States government, the Bush administration, declared war on the Rome Statute and the ICC formally in the same month that 11 governments deposited their instruments of ratification at the UN in April of 2002. And the entry into force of the Rome Statute would happen 90 days after the next first of the month, which was July 1, 2002. And the United States launched a multi-pronged war at the UN, bilaterally in diplomats and in the United States Congress against the treaty, all right? And when the treaty entered into force, the last preparatory commission of the General Assembly was finishing its work, and the United States across the hall was threatening vetoes of renewing fundamental peace operations by the UN unless they got an illegal Article 16, which they secured on July 12th of 2002. So the 6 years later, after the Iraq War, and after the Abu Ghraib disaster in Iraq, the United States put up the white flag. They could not even get the Security Council to renew their Article 16. Actually, 2 years later, but 6 years later, they surrendered, and the Secretary of State and the head of the Joint Chiefs of Staff went to Congress and said, please rescind these anti-ICC laws, we're shooting ourselves in the foot. Not because they wanted to get positively involved, because they were losing. They were losing to China and Russia and others in military trading, in not being able to train other soldiers. They were losing on a whole bunch of fronts. So the message there ought to be understood. It wasn't that the court became more friendly towards the United States. And honestly, the terrible laws in the Congress are still there against the ICC. I just want to, if I can, quickly say that I'm introduced here as the Coalition for the International Criminal Court, and it is a global network, and I've been deeply honored to serve as a convener for many years now. But because of the discussion here, I'm going to also have to answer some things not as CICC chair, but as a Secretary General of an old peace movement that's worked on these issues for the last 69 years, the WFM and the Institute for Global Policy. The ICC was achieved in the General Assembly. It was a UN process. It was a General Assembly looking at the Security Council against all expectations at the end of the Cold War, setting up the Rwanda and the Yugoslav tribunals, but then the governments, the small and middle-sized democracies, wanted to set up a permanent independent court not controlled by the Security Council. The Rome Statute is an enormously important. It also occurs because it was at the end of the Cold War, which we had hoped would be the end of 500 years of colonialism and empire and a few major powers running most of the politics on the planet. It was also at a time when the then Secretary General introduced an agenda for peace. You had the decade on peace and the rule of law in international affairs. The ICC, in fact, was developed within the framework of peace and justice in that decade. As I said, the Rome Statute is enormously significant. Actually, to the question, after the reaction to Iraq, the 2005 UN summit was converted from a +5 summit on the Millennium Development Goals to a reform summit, and it did succeed. It failed in many ways, but it succeeded in establishing the Peacebuilding Commission, the Human Rights Council, which changed its procedures from selective to universal periodic review of everyone, and responsibility to protect, which took the ICC crimes, the Rome Statute crimes, and said, yes, that applies to individual responsibility. Now, what's the state's responsibility? And responsibility to protect addresses that. And I brought some documents that I'm welcome to share on all of this, on how these are all integrated. So I think the description of the ICC as punishment and retributive justice has really missed the very multidimensional reality of how this enormous treaty came into being. The vote was 120 to 7. It was an unrecorded vote, but we know from some of the countries' comments who did it. The US voted no, China voted no, Israel voted no, Sudan voted no. Okay, so from the very beginning, we saw some of this playing out. Russia, which voted yes, would of course today vote no, and that's one of the most important points I want to make, is that we could not get the Rome Statute approved today. There would very unlikely in a treaty, I think it's absolutely certain there would be no immunity or no end of immunity for heads of governments and other government officials. Probably no independence in the judges, no independent prosecutor, no proprio motu, automatic jurisdiction. There would be opt-in jurisdiction, no strong complementarity, no transnational jurisdiction that exists. The very unlikely that the strengthening of the crimes against humanity and war crimes on the gender-related justice issues and crimes would not occur. Many other provisions could not be achieved today. So I think it's very important and the role that South Africa played in the SADC in the 1995 to 2000 period in being the strength country moving forward on this continent was absolutely crucial, and anything that we can do to try and restore that, I think, would be extremely important. The issue is that this is to succeed on what we're doing is really the kind of challenge that a number of colleagues here have raised in terms of whether we're going to get to a world of the rule of law instead of the rule by law, whether we're going to get to a world in which the biggest powers, whether regionally, sub-regionally, or globally, dominate the international legal order with impunity, or whether you will, in fact, have a more even playing field, and whether we're going to get where national legal systems, and if we had all 124 functioning, investigating and prosecuting, and had the kind of human rights and justice institutions, independent judges, we could succeed. And this can only happen in a really multi-dimensional, not a two-dimensional way. It has to be civil society, the way the South African Litigation Center and others in this country have been operating. It has to happen with national parliamentarians, has to happen with progressive governments, judges, with regional international NGOs, with international NGOs. We all have to work together. It is a synergy, and it's multidimensional. It's not two-dimensional. Thank you.
Great, thanks very much, Bill. We heard from the President's comments today a little bit about preliminary examinations, and one of the responses, and Tim, I want to ask you about this, one of the responses to allegations of African bias by the ICC is that it has preliminary examinations outside of the continent. That didn't seem to resonate with many people who perceive the court as being biased against Africa. However, more recently, there has been the first full open investigation outside of the continent in Georgia. Does it matter now that the ICC is quote unquote out of Africa as well as in Africa? And will this change, in your view, the perceptions that exist about this relationship between the court and the African continent?
Thanks, Mark. I think on the issue of preliminary investigations, the issue is how many of those preliminary investigations, in fact, come into fruition as full-blown cases, prosecutorial cases. And to have 9 cases coming from the African continent and none until recently from anywhere else in the world, I think it's a major problem. The speed at which the Libyan case went from preliminary to full-blown, is a major issue that still needs to be unpacked and explained much more effectively to the African constituency, because there is a perception that, okay, here is an enemy of the West, and very quickly we have a Security Council resolution, so on and so forth. But this actually speaks to a much wider issue of the fact that despite the wishes of the President of the ICC and the statement of the Attorney General of Botswana, the ICC is in fact a political actor. It emerged from a geopolitical process of negotiation, and Bill explained that very well. And it operates within an extremely volatile political context where there is full-blown war fighting going on. And therefore you cannot actually escape from that reality. The 5 cases that African governments have referred themselves, Judge Goldstone made a reference to, if you analyze politically those cases, you will see those heads of state who, in fact, some of them are warlords that just happen to be presidents, refer their political and military opponents to the ICC. They do not refer their own soldiers and generals to the ICC, the Ugandan People's Defense Force. Oh, sorry, you can name them. You can name, it's important to do that analysis. It's important for that to be understood within the system. The two cases from the UN Security Council. I'm glad I'm generating a lot of debate. The two cases from the Security Council are politicized, and the OTP 2 proprio mutu cases. If you analyze that politically again, you will see there was politics, and therefore the ICC is completely embedded in politics. To try to escape from politics is to do yourselves a great disservice, in fact. So one of the things that needs to happen is a paradigm shift, and it probably will not happen in reality. It will happen here in the halls of thinking first, before we see it in reality. So it will be a number of years before we get there. But in fact, that's the shift that needs to take place. The fact that you have Security Council referring to Sudan and Libya, and completely failing to refer Syria because of the geopolitics and the international brinksmanship of the P5, the Machiavellian manipulation of the Security Council, means again that who are you speaking to, guys? Look, it's evident that this thing is political. So you need to acknowledge that. I'm going to give you guys one thing to take away with. The establishment of the African Union Court of Justice and Human Rights, which you could argue is a sign, look here, Africans are not against accountability and justice. They've established the African Court. There's an extraordinary chambers in Senegal. The establishment of the African Court of Justice and Human Rights, I will give you that is a geopolitical act. It's got nothing to do with international criminal law. I stand to be, exactly. But I'm giving you that the African Union is playing precisely the same game that the P5 are playing. And so international criminal justice, as you know it, has been mangled to beyond recognition.
Can I just add one thing I want to answer? I think to some degree you're absolutely correct that the Security Council is incapable of not making all of its decisions based upon extreme political considerations, right? Okay. Almost none of us expected that the Council would ever refer a matter because of the opposition of the United States, China, and Russia. It's been astounding that they did, and they did it because of the P5, and on Libya they did it because of the Arab League and the OIC insisting on something happening by the Council in that situation. But the point is that just because the Council is incapable of not treating the court as a judicial institution, it has to treat it as a political tool, which it doesn't mean we should allow the court to be treated as a political tool. We need to protect the court as a judicial institution, and that's what we're dedicated to doing, and that's what I'm saying, is that this is not a court set up and controlled by the P5. This is a court set up and controlled by small and middle power countries, including this country, and to protect it is the most important thing that we can do. But I agree with the comment earlier that I don't see the opposition to the courts exercising on the request through the charter of the Council, its jurisdiction as selective justice. I think the question is, do the opponents of the ICC really want any justice to be exercised on them as leaders?
I know Jim and Charles, you both want to come in on this point, so.
Well, just very briefly, I mean, I think it's perfectly appropriate to recognize that, it has been said repeatedly, the court is a reflection of, embedded in political processes, deeply contentious issues. But it's quite another to say that the court takes decisions on the basis of political factors. And I think, as we've heard this morning, and it has to be true, the court is a judicial institution in a political world. It has to act like a judicial institution. That means fidelity to the law, following the evidence, sticking by the rules. That is why it's so contentious. It is seeking to inject the rule of law into a fundamentally political set of circumstances wherever it goes. But that, and the court, therefore, I think, maybe court officials, there are certain things they can say about what they do. They have to stick very strictly to that line. We follow the evidence, we stick to the law. That's very, very important for the legitimacy of the institution. But that does not mean that civil society advocates or states who are supporting the court need to so restrict themselves, and we should and can be freer to highlight where others are not supporting the court, to highlight where others are using the court as a political tool, and to find ways to help the court where in order to accomplish its judicial mission. So I think one needs to distinguish between what has produced the court and the environment in which the court lives and exists from the manner in which the court itself comports itself.
Okay, this is obviously a key then issue here, and it seems there's a kind of a tension or perhaps this ongoing nexus between politics and law and the court as a criminal court and the court in its other hat, which is that it's an international organization that deals with other political entities like the Security Council. I know, Charles, you wanted to say something about this as well, right?
Very briefly.
Yeah, of course.
And only because I think it's a fundamental question for the court. And again, I'm very convinced, having followed the progress of the court, consider myself a supporter of the court and so on, that we don't run away as lawyers. It's very interesting for me how it's almost like I need to be a legal anthropologist or something and go back to, how anthropologists embed themselves in an environment. Lawyers are terribly afraid of politics. And that's because we are technicians. We are told the law is over there and politics is over there. A lot of us, maybe not all of us, but a lot of us. And so part of the difficulty is, and it goes back to the comments by everybody on the panel pretty much, and I really, especially towards the end there, James's comments about sort of thinking about the court as a international organization, as an entity that functions in a broader Westphalian state-based system. And the other part of the court being significant, which is a judicial independence and an entity that has to show results as a judicial institution that has to be insulated from that politics. The difficulty, of course, is how we kind of straddle that. And I think that one of the suggestions that I want to echo is that, yes, civil society, academics, and people outside of the court can definitely be more freer. We should take up, and I'm actually going to note progress here, because a few years ago, a lot of us would not accept on the table that the council is a problem. And I'm sorry to be a little bit blunt about this, but there's a north-south divide around the question. A lot of people from the global south will accept very easily that, oh yeah, we see the problem about the Security Council. But now already refreshing change of heart in terms of where we are as experts who could come to the discussion and say, yeah, we recognize that, but then how do we do better? Because we need to insulate the institution from the politics. And I think that's where I see the promise. And so just to underscore that at a technical level, we can make those complaints. Again, within its mandate, within its authority, I think it's going to get big legitimacy points for the court to use its statute when it can. And again, I'm suggesting here again about the kinds of referrals it's been receiving. Again, it's not going to be that you say to the court, well, where is your authority? Because they say, well, by the way, Article 115, it says that. And again, you might have pushback from the usual suspects, but again, at least you're giving your voice. Because remember, if you go back to all of these instances, we talked about Yugoslavia, the Rwanda situation was also equally political. Who remembers Baragawiza? Some people too familiarly, right, with Baragawiza. We thought it would be the end of the tribunal. But we got good judicial decisions, and we moved on, and we just closed the tribunal with much success. I mean, again, it's not fully satisfactory for everybody, but nobody can say that it wasn't worth the effort. So in a sense, nobody could say the ICC doesn't have a place. It's just that the ICC does have that legal place, but also slightly political space, and then the rest of us have to jump in and get in on it. Thank you.
Yeah, thanks for that. And I think what some of these comments also highlight is how difficult of a position the ICC is in the sense that there's a lot of blame placed on the court for accepting politicized referrals on the one hand, and then also insisting that it must somehow, and that we should get Syria referred to the court.
Accepting referrals from a politicized entity, that's not necessarily a politicized. There were real crimes happening that were referred. So,
and I think that's really interesting that the court, in a sense, is criticized for being too close to the Security Council on the one hand, and almost in the same breath for being sometimes too far from the Security Council. But I wanted to ask, because we have a number of civil society representatives on this panel, and because the responsibility for this relationship or for the tensions within this relationship tend to be put on either African states, the International Criminal Court itself, or in certain instances at the UN Security Council. But I wonder, should civil society organizations take responsibility for this relationship as well, for the way that this relationship currently exists? And what can they do now? Bill said that we need all these actors to work together. What can they do now to better the relationship in a meaningful and effective way? Liz?
Big question, big question. I think that if you're asking whether civil society should take responsibility for the relationship, I think in a way all of our joint and individual advocacy over the years is, in a sense, not taking responsibility for the relationship that belongs to individual member states, but taking responsibility for trying to shape some of the discussion and the narrative and to pierce through some of the misperceptions that have complicated the space in which the ICC has to operate. So I do think that there is certainly a role for civil society there. I think, though, we do need to come to a juncture where we can have some fresh thinking about just what can civil society do? I mentioned before that for the last, really going back to 2009, my organization, along with many others, and many of them are in this room as well, and pre-existing networks like the CICC, like ISS, like Amnesty, we have been trying to work together along sort of 3 different tracks to strengthen a cross-continental voice of support for justice for international crimes, to engage with the media to correct information around the ICC, and to engage with governments, to get more governments to be willing to speak up at crucial moments, for example, in the context of AU summits, when decisions are being debated that are quite detrimental to delivering justice for these crimes. I think on the first 2, and again, there are many fellow activists in the audience, so I would welcome their reflections too. I think on the first 2, we can say we've had some success. If you go to an Assembly of States Parties meeting, you will see civil society working together. You will see in the margins of African Union summits, when it's been possible, civil society working together, trying to demonstrate that there is a very active constituency for justice, and increasingly working not just with civil society groups in Africa, but also beyond, because I think, as others have mentioned, there are a number of fires that are being set around the International Justice Project, and they haven't all been set by African leaders or by the AU. The same thing on the media. I mean, I already highlighted the recent example from the AU summit of at least trying to put some distance between immediate reporting that there had been a vote of mass withdrawal and a potential strategy. Again, still a very serious thing, but not what was being reported. When it comes to engaging governments, it's been very, very difficult. And I'm sort of hard-pressed for us to really mount up successes there. In fact, in those 6 or 7 years, we've seen fewer governments that are willing to speak up when it matters most. And again, not confined to African states. We also see a real weakness of global support for the ICC. We see really damaging movements by a number of states in Europe, Japan, Canada, who want to continue to put a lot of pressure on the ICC so that many of the performance problems that others have highlighted, and that we, of course, very much share and try to be as publicly critical as we can be when we think that the ICC is making the wrong decisions. Solving some of those problems requires the court having the capacity to do it and the personnel to do it. And so those have been damaging movements as well. And I could talk more about some of the specific efforts that we've tried, but oftentimes what you might see from this collective informal network are letters making recommendations to African governments about steps they could take at the AU summit. Those letters are then taken up by individual groups in their countries, going to see the Ministry of Foreign Affairs, going to see the Ministry of Justice. There have been very strong, this is not, this is not really fun work. To be on the defensive all the time about the core principle of delivering justice is not necessarily what, makes you want to get out of bed every day. And yet people have been in the trenches day in and day out trying to engage, trying to go back to basics to explain why justice matters and why the ICC matters. And we don't have many results from that when it comes to African governments at least being willing to say what needs to be said at the most difficult moments. So that's why I say I think that, this discussion discussion, I hope over the next couple of days, can help to generate fresh thinking. I think the African Group for Justice and Accountability, I think one reason why it holds out such promise and potential from our point of view is because it maybe has some things that civil society doesn't have when it comes to prominence, when it comes to influence, when it comes to accessing governments. We do our best. Many organizations do their best, but I think there's something that could be more transformative about having this particular group of individuals engaged on these issues. I would say the other area that we probably need to put more attention to is how do you talk to not to the leaders but to people about the importance of international justice. I don't think that that's been such a focus of our work. Certainly trying to influence the media to be accurate in its reporting has been a strong focus, but I think that's been about trying to shape the debate, trying to reach decision makers to make sure that people understand what's really going on and have the accurate information. It's quite a different thing to try to get a sense of what public perception is on these issues, to influence that public perception. I'm just speaking now about Human Rights Watch's work because, again, many different NGOs doing lots of different diverse things. I think that we could probably try to do a better job of, as Justice Goldstone said, that the middle has disappeared. How do we try to recreate that middle, and how do we try to recreate that by having discussions not in Addis, not in The Hague at the ASP, but among people about what the value and what is at stake of these kinds of discussions about the relationship between Africa and the ICC.
Thanks very much for that. I want to turn to Charles for a second. I don't think anyone could have guessed that the most important positive development regarding the Bashir case would happen domestically rather than at the ICC a couple of years ago, perhaps even a couple of months ago. And this kind of brings to the fore this issue, or what some people call it, the complementarity turn, and the possibility that the future of international criminal justice is regional and domestic. And one of the key aspects to this responses, perhaps, that we hear often on the African continent is this extension of the African Court for Human and People's Rights to cover international crimes. We saw the ICC Chief Prosecutor just a couple of weeks ago say that she's all in favor for such an organization. But I want to ask you, because you've been working quite a bit on the subject, Charles, is this a real alternative?
Well, first of all, I have to say I disagree with Tim's assessment. I tend to agree a lot with Tim, but I disagree with the assessment that the project itself, the AU project to create a criminal chamber within the African Court of Justice and Human Rights, is equivalent to what the big boys are doing in the big boys club in the Security Council. And the reason why I say that is that I can actually confidently say that I stand on the legs of history for the proposition that, in fact, when the African states gathered for the first time, after many years of discussions and pushing civil society advocacy, going back to the law of Lagos in the 60s and what have you, to draft a regional human rights convention where they were going to think about the type of tribunal that they would have, whether to have a commission or a court and so on. There was, in fact, a proposal to create criminal jurisdiction for the African region. This was a proposal by Guinea. Of course, we're in South Africa, and I have to note that that was driven by their interest in apartheid. And of course, we know that African states and Guinea, along with Russia, were the key leaders. You could go back to the proposals in the UN system to have a convention that would prohibit apartheid and make it a crime against humanity. And the response that was given to Guinea was, wait a second, guys, African states are not ready for a regional court that would have enforcement over human rights. And on top of that, you want to add criminal jurisdiction. We don't think it's a good idea. So why don't we hold off on that? We could revisit both the idea of the court later on and, of course, criminal jurisdiction. Well, it turns out that there are processes at the International Law Commission at the time dealing with questions around the Code of Crimes against the peace and security of mankind. And as part of that, the attendant institutional framework to give effect, so an international penal tribunal. So there's a long history of wanting to deal with essentially problems that are particular to the continent. How does this all relate to the ICC? Well, it turns out many, many years later, when we were dealing with Mr. Harbury, so this is really an important point, because I think there's a lot of misperception. We talk about a theme of misperceptions. A lot of people would think that the protocol was drafted because, you go to 1979, the record is there. And then you fast forward, the AU states created a special committee of jurists to recommend what to do with Mr. Habre. So in a sense, we talked about the extraordinary chambers earlier as a great example. The judge referred to that. This is a fantastic example. Oh, I'm sorry. The criminal chamber in Senegal. But one of the recommendations that came out of that process was that to deal with these kinds of issues in the long term, they also needed to think about a permanent framework. They proposed criminal jurisdiction. Of course, for various reasons, African states didn't pick it up. And of course, honestly, yes, universal jurisdiction and ICC concerns did resuscitate it a little bit and push it forward. That we can admit. That's all true. But the reality is that the protocol we have now, in a sense, has a long pedigree. And what I find interesting about it is that three points I can make in the limited time I have. One is that it goes, of course, in line with the interest in dealing with accountability for international crimes. It deals with all the Rome Statute crimes. So you have genocide, war crimes, crimes against humanity, and the crime of aggression. And on top of that, 10 additional crimes that are transnational crimes, dealing with essentially issues of particular concerns to African states, some of which are really interesting because they had been, if you go back historically, part of the discussions in the 1950s in the International Law Commission. For example, drug trafficking. In the end, the code that was adopted in the 90s did not include that. It's very, very interesting how at the regional level there could be the kind of agreement there. This is what I call ICC plus. And my theory is that the ICC system sets up a benchmark. It's this floor, not a ceiling. And so if you have a region stepping up to deal with offenses, to give more accountability, because we've seen the assumption at Rome about complementarity, that national systems will be able to discharge that responsibility, is a bit of a difficult assumption, because we of course then end up having to build capacity, and a lot of countries are in trouble and they have to get the support of external actors to build, again have a special chamber in Uganda and what have you. So my point is, in terms of takeaway, the regional has a place. And there is precedent for that in international law. If you go to the human rights system, there was a time when we thought international was best. We have seen incredible advances in human rights by regional courts. So one point to make is that positive complementarity with a regional court that has Rome Statute plus as a minimum, Rome Statute crimes plus more, I think is a welcome development. Second thing, that in the African system, because of the pressure on the court, I think it would definitely release a little bit of that pressure on the court, because ultimately, as the judge pointed out earlier, the ICC is not going to be able to meet all the expectations of victims. And as part of what they have in the African system, the same trust fund idea for victims has been incorporated. I find that fascinating, given the resource implications. And the third point is, of course, the big caveat. Are they going to put the money where their mouths are? And this is a question you can raise for all states. It's about the human rights system and international law more broadly. So I want to bring it to the issue, not the region, so we can kind of discuss those elements. And so for me, my takeaway is that there is a regional that could be interposed, so national, regional, and international, and that you could have a burden sharing, middle-level individuals perhaps to the national systems, lower-level individuals and middle-level individuals to regional systems. And of course, I'm not worried about immunity, because those bearing greatest responsibility will always have a place in The Hague.
Great. So before I open it up to some questions from the floor, I did ask in advance, I asked all of the panelists to do something which is maybe unfair, but hopefully important and interesting, which is in 1 or 2 sentences or 1.5 sentences, to come up with one policy or decision that the ICC can implement almost immediately that you think will help the court's relationship with Africa, and one thing that an African actor, be it civil society or state, can do to improve that relationship. So Jim?
So I think the ICC should essentially keep getting better at doing what it is supposed to do and engage in effective investigations, prosecutions, and trials, not only where it is an investigation, but hopefully in a number of the places beyond Africa that are now in preliminary examination as well. And in terms of what states can do, I mean, I think they should, the most important thing that states can do is to follow the law. In South Africa, follow your own courts. In Kenya, there are cases in the domestic system seeking accountability for what happened in the 2007 and 8 violence. Follow those court decisions, allow them to proceed, and do what you're supposed to do. I think states can do most by simply ensuring that their obligations under the Rome Statute are implemented.
Liz?
Great. Well, I definitely agree with Jim's first point about what the ICC can do. Continuing to heighten the ICC's importance. If this is a court that is having real impact in the lives of the victims that it was set up to serve, I do believe it will be a more resilient institution to the kinds of unprincipled attacks that we've seen. But so as to have something new to say, I will say that while I definitely associate with my remarks with, or associate myself with the remarks that the ICC should think of itself as a judicial institution, that's what it is. It still does need to engage. It needs to engage, particularly with African governments and African leaders. It needs to be more present here. It needs to be understood. So it's not to promote a political agenda that it should be engaging with these governments, but to promote an understanding of its mandate and what it's doing. So having those kinds of meetings with African governments at the highest levels, of course the ICC has had difficulty in accessing some of those key places like in Addis. But we also think that something practical could be something like an opinion column, a monthly column in some of the cross-continental or regional press where the ICC is just more of a face. It's just more of a thing. It's not a phantom. It's not a threat. It's not a menace. It's a functioning, working institution, and it's working on behalf of justice at the end of the day. In terms of African actors, I think I'll just maybe go back to what I said before. Our lesson from some of the civil society work has been very, very difficult to engage governments in a way that will transform their positions when it matters most. And we do really see real potential for the African Group for Justice and Accountability, for this exceptional group of people to be able to use their influence, their access to networks, their public prominence, to be out there and to engage with governments and hopefully bring about more of that transformation.
Thanks, Liz. Tim.
Thank Mark. I think Charles mentioned that lawyers are afraid of politics. I think that's an interesting kind of angle to take for the ICC itself. The Office of the Prosecutor can do a lot to demonstrate that she is aware of the highly politicized context in which she is operating. Reno Campo issued a paper in the interests of justice, where he talked about, on notions of justice, where he talked about the potential role that different accountability mechanisms can play. I think it's time now for something similar as an instrument for the OTP to actually communicate to AU member states. Because I think otherwise this notion will continue of the bias. The AU member states should not use the African court as a means to entrench head of state impunity. So Charles, on that basis, I agree with you, there's a lot of work that has been done. I was using a little bit of hyperbole for theatrical effect.
Okay.
The issue of complementarity for regional organizations does not exist in the Rome Statute. There's a lot of work to be done there to figure it out. It goes to your point, Mark, that you raised. So I think that's something that African countries should do, because they're the ones now that have brought forth this African court. Just very quickly there's a chairperson of the Independent Commission of Inquiry for Syria, Paolo Pinheiro, who has said that the war crimes in Syria will not wait for the end of the war. In the interests of international criminal justice, and I think the point there that we should help lay people to understand what international criminal justice is all about, I do hope that the focus on war crimes in Syria will also include the atrocities committed by the 4 permanent members of the Security Council, the United States, Russia, UK, and France. You could add Turkey and Iran. But I am sure that will not happen somehow. And in fact, you can perhaps, we could do a nice little time frame to see if and ever these powerful countries who were bombing wantonly, even at the beginning, without a UN Security Council resolution, whether they will be brought to book and whether accountability, in fact, will emerge for the Syrian victims. And this should be an issue that Europe is concerned about because of the refugee crisis that we have at the moment. For Wayamo, I think it's a great initiative to have this accountability group. I would say expand it, put Aung San Suu Kyi, Ramos Horta, so it becomes a global justice. It's not about African justice, it's about global justice.
Thanks. Bill, one policy for each.
Okay. Well, for the coalition, I think we see the three organs, of the main organs of the court, as a very fundamental core. But there is basically a fourth organ of the court, and that's its governing body, the Assembly of State Parties. And it has not only governing responsibilities, but the whole cooperation regime of the Rome Statute system is dependent on it. So for me, I would hope that the Assembly of State Parties will itself take on its importance of reforming and strengthening itself. And related to our work here today, our discussions today, there is an important initiative on insisting that the permanent members of the Security Council and anyone elected to the Council would not use the veto or allow the veto to be used in terms of war crimes, crimes against humanity, and genocide. So that is something that the Assembly could advance enormously in my mind. Secondly, for African, I think the one I would suggest today is that we've had groups like the South African Litigation Center, we've had Kenya groups do enormous things on Bashir, say, in Kenya and against their own government. Nigeria went to court on the Bashir issue also. So one of the most important things is for African NGOs and progressive parliamentarians to support and protect the human rights and international justice defenders.
Thanks, Bill. Charles.
Thank you. I think, yes, I know, one. So, the moderator, because I happen to sit right next to him, he can wag his finger a bit bigger at me. So, I was going to actually joke, but maybe not appropriate anymore. I was going to say, why don't you drop the Kenyan cases and the problem will be solved? But no, not that. On a serious note, from the point of view of the court, a lot of my ideas around Article 53, interests of justice and so on, I think the court could be more open to this initiative of the African Criminal Chamber. And the reason why I say that is that if you look at the Inter-American system, there in fact is long precedent where the Inter-American Commission and the court have been able to use quite effectively, essentially like a police power that they created to wag their fingers at states and have the states prosecute serious crimes on the idea that people who have been victims of disappearances and torture and so on ought to get justice. So already, and this is academics are talking about this as quasi-criminal jurisdiction of the inter-American system. So in a sense, work on positive complementarity, engage. There has been too much distancing. I think the engagement would help. On the side of African states, I want to be very modest. Cooperation, of course, is always great. That's where we want to start. And as part of the cooperation, I'm thinking just have a liaison office. Allow the ICC to have the office they've been asking for. And conversely, the ICC should invite the AU to have, so turn it around in the AU. Since they're dragging their feet about giving the office, the liaison office in Addis, well, you invite them, give them an office in The Hague. We'll see, it'll be interesting to see what happens. Thank you.
All right, so with that, I'm sure there's lots of questions. I don't know if we have microphones anymore. Do we? Yes, we do. Okay, so I see Stephen Lamoni. Actually, maybe we'll get a question from the back, and then Stephen, and then I see a number of questions here. So we'll take maybe these four. Yes, please.
Introduce yourself.
Yes, please introduce yourself and keep your questions to questions.
And one question.
And one question. One question.
My name is Donette Odhiambo. I'm from UWC Law. And it's more of a question within a comment. So realizing that the biggest fan base of the International Court is the African Union, and also acknowledging that the threat to withdraw is real and imminent. Could the solution to this tension between the International Court and the African Union be beyond the liaison that is proposed by Charles, I think, and that the international community should come together and offer capacity and infrastructure for the proposed African Court, so that their responsibility is then on the African nation, where the international community is saying apply or apply, not apply and explain.
Thank you very much. Please here, and then Stephen. Mr. Tobiko.
Thank you. Thank you so very much. Keriako Tobiko from Kenya. Just maybe two questions. Firstly, Charles, you mentioned about the problematic issue about the UN Security Council referral. I think Article 115 or 116. What is the alternative? Is there an alternative to that? Number two, the question about complementarity and the African, the regional justice system. Would the existence of the African Criminal Court undertaking genuine criminal proceeding provide ground for the admissibility or jurisdictional exemption? Would ICC accept to disavow jurisdiction because there is a genuine proceeding before a regional court as opposed to proceeding in a national court?
Thank you very much. Fatia. Is there a mic? Yeah.
I always say oops. I had maybe three reflections. One already put forward on the Security Council and the political influence of the Security Council in a number of frameworks. I wanted to welcome, and by the way, thank you to the panelists. It was one of the best, most open. I come from the UN, and it was one of the best open dialogue. I wanted to welcome the point about no justice, no peace without justice, and the other way around. We know, in general, that for the sake of a political solution, it's actually the justice that is sacrificed. And I think your point was very, very important. The second point I wanted to bring about is the question of double standards. In the sense that if we today have in Africa and elsewhere many people reacting against the ICC or other political situation, is because there are double standards. The example about Syria is a good one. I can tell you from my time in Somalia that for the sake of killing one Al-Shabaab leader, your policy of protecting citizens goes out of the way, and you can kill 100 people in order to kill one. Is a very important question that we need to address, but we never think about it. I think that's very important. And I wanted to come back to you, Liz, about your question about how can we create a larger constituency in support of the ICC because of civil society, and we worked with the Human Rights Watch on issues of justice for victims of rape and abuse. And I can only see the only way is by actually showing that there is reparation and that victims can see a result in relation to their situation. If we increase the number of victims who see that they have justice, then you will increase the constituency in support of the ICC. Thank you very much.
Thank you. And Stephen. Stephen Lamoni here, please.
Thank you. My question is to Tim. You said that the AU would issue a statement following the verdict against Jean-Pierre Bemba. And my question to you is why? I'll explain to you why I'm asking why. Jean-Pierre Bemba was the runner-up in the DRS elections in 2006, an important year, which Charles Jella has kind of mentioned. The same year is when the AU recommended that Hissène Habré should be prosecuted in the name of Africa. Secondly, Jean-Pierre Bemba was arrested 2 years after that in Belgium when he was in exile. So I just want a clarification on why the AU would issue a statement when Jean-Pierre Bemba was not a head of state or a senior government official at that time when he was arrested.
Okay, thank you very much. Let's maybe take it from right to left. So try and be as quick as possible. So, Liz, please.
Well, I'll just speak to 2 points that were made. One, and a couple of references I think were made to what could be the importance of providing capacity, providing technical assistance to national jurisdictions that want to do international crimes. I think that this has been out there, and that there has been a commitment from ICC officials to pursue these kinds of projects, which have come to be known as positive complementarity. But the reality has been that this has not been something that's been popular with states parties. The court has been actively discouraged from having this role. Every time it comes up, the question states parties have is a very, penny wise, pound foolish. Well, how much will this cost? What will it add to your budget? You're not a development agency. So while I certainly would want for ICC officials to have pursued this more genuinely and more seriously, I mean, there is good work that's been done, but it's been done on sort of an ad hoc basis from each of the ICC's organs. One has to ask what is really realistic given that. And I guess our work then is to go back to states parties and to insist that actually this court is very uniquely positioned. The ad hoc tribunals who had to close down, doing this kind of capacity building and technical assistance became an essential part of their completion strategy. But to be able to do that, they had to build new partnerships. They had to find the development actors to come into the circle. The ICC benefits from having an assembly of states parties. You have the political actors there. You have the political actors who have their development agencies there. So to me, it's really a tremendous missed opportunity that the Assembly of States Parties hasn't really seized the moment that was opened a little bit during the ICC review conference in 2010 to really go further in this direction. But I would put more of the blame on states parties for their not understanding the opportunity that's before them. And at the same time, given even with that context, I would think that ICC officials could look to do more and have more of a strategy about positive complementarity. And then, thank you very much for your comment. I mean, a big part of our work when it comes to engaging with court officials is to get them to realize the importance of putting an impact with affected communities at the heart of their work. This has to be the driving vision for the ICC. Again, though, the challenges to achieving that are tremendous, and I think, of course, this is not going to be a court that will ever be able to satisfy even the 5,000 victims, with the largest number of victims participating in a case so far before the ICC in the Bemba case. But in most cases, we've seen far fewer victims that have been able to participate. It's difficult to know how to best shape and manage and inform, really more than manage, but inform the expectations of victims of what can the ICC do, what will other actors have to do so that they do feel that sense of justice.
Jim, please.
Yeah, thank you. So just quickly on the capacity building point, I just wanted to make 3 points. One, capacity building is critical. I mean, rule of law promotion around the world is still a very much needed project. The ICC and these kinds of crimes are part of that, as has been said. But my own view is that the ICC itself, the court itself, is so overtaxed with the extraordinary challenges that it has that it will never be able to devote more than a very small portion of its time, energy, and resources to that particular project. Now, that does not mean, as has been said, that states cannot do an enormous amount more. And now that justice is part of the 2030 development agenda, now that the World Bank has underscored with empirical evidence the costs that conflict poses to economic and social development, states have more and more reason to do that. But all that said, we need to be realistic here about what is at stake. Capacity building is not a substitute for political will. There is no need to build capacity in South Africa to adhere to its own courts. There is no need to build capacity in Kenya to undertake effective prosecutions of the post-election violence. So we just need to be realistic about what's at stake.
Thanks very much. Charles, please.
Okay, I'll try to be very brief. And Jim made that easy in many ways, because on the one hand, I'm an advocate of the idea that the court should engage, especially the elements that relate directly to its mandate, because I do think that it was an assumption of complementarity. Remember we had that debate about whether to have primacy versus complementarity? In a sense, it was seen by some people as a loss. I mean, when you look back and you're like, it's so unrealistic to even think the model that applied in single situations like Yugoslavia and Rwanda or Sierra Leone could work at a global level. It just doesn't. So complementarity is the answer, but then the difficulty is the assumptions were made are not real, so capacity building is important, but of course not the court's job. The court should prosecute cases in an independent manner and give the justice that it could, knowing how limited that justice would be in many of the contexts. So just to underscore that. Second point, that was directly raised about what could you do around Article 115, 116, and this is the part that basically says that the council should pay for its referrals. The exception was built in there by the US, we all know that. I think there is a movement to some extent that builds off of this notion by Liechtenstein and other states in the UN system to say, look, we want to get a soft commitment from you, a number of smaller states, to not use your veto power. And I think as part of that, you might release a little bit of pressure off of the process, because essentially it was like, if we don't get this, including the Article 16 deferrals that the US wanted, we're not going to support that to go to Darfur. And so the US got compromises from the system because it could exercise that power. So to what extent could we see a little bit more friendly action from the part of the United States by the soft commitments that states are making, including, importantly, let's not forget the council is made up of 10 other states too. So 15 in total, but P10 exists. So again, there might be possibilities there. The other one was to go say, maybe the court should look more closely at the referrals in terms of assessing. I'm talking about both the prosecutor and then the next level up. And finally, on there was a point about civil society that I wanted to pick up on, and I think it's an important point because, Liz, you raised it. And I happen to have had the privilege at the end of the process with the Malabo Protocol to be in the room, and I have to say I was a bit disappointed because the advocacy that was being done essentially was, and this is not meant to be a criticism, just in terms of improvement, was, the letters come in, we are opposed to immunity. But there was no civil society actors in the room. And part of that, of course, is the inaccessibility of governments. But one had the feeling that part of that had been almost set up inevitably to fail by the decision by the East African Law Society, a number of groups, to condemn the whole project. So maybe we are sometimes in our hastiness, we can make decisions that now make it difficult for us to advocate. So just raise it in terms of going forward, that maybe we deliberate a bit more before we take a formal position, because when we engage, we get better results.
Thank you, Charles. Bill, please.
Well, very quickly, I think the question of positive complementarity is important, and in fact, where you may not need certain kinds of structural capacity support, you certainly need capacity support to resist being silent about impunity. And so the international community has tolerated leaders who have completely misrepresented the ICC and this whole, and their lack of responsibility to implementing their own national legislation. So, and I think the linkage between complementarity and the role of the Assembly of State Parties, responsibility to protect Ambassador from Switzerland, you might be interested that there's been linkages throughout this morning. Don Dea, who's the head of the Pan-African Lawyers Union, is, like my group, are on the steering committee for GAMAC. GAMAC is a complementarity, potential complementarity. And President Fernandez, in a previous life, was one of the parents of the founding of GAMAC way back when. So this whole issue of complementarity, I think, is fundamental. And from Tim, I think he really does misunderstand complementarity, and I think that's something we really need to educate, the dimensions and the complexity of complementarity. On the double standards and peace and justice issue, I would just say you can accuse mistakes at the court and some of the other issues of the court as being responsible maybe for 2% of the selectivity. 98% of the selectivity on this is due to lack of jurisdiction because governments haven't ratified, because leaders are opposed to international justice and international institutions, and the misrepresentation by the media, etc. So, and of course, heads of governments who are accused, who oppose the court. That's the real selectivity. That's the bulk of the selectivity issue.
Thanks very much. And finally, Tim, please.
Thanks, Mark. Firstly, on Steve's point, Steve, I did not say that there would be a statement. I said there would be a reaction, a political reaction. So perhaps continuing with the theme of misperception and misunderstanding. I seem to be a victim, so I would like the judges to... Bill, I'm not sure if we have completely different understandings of complementarity. I have written on this issue. I can email you some of my articles to show you that it's completely in line with what the Rome Statute says. Very quickly on the issue of justice, Lydia's issue of justice, is sacrificed. I think this is a very important thing that we need to engage with. You say for the sake of a political solution, justice is sacrificed. But I would say that Article 29 of the Rome Statute, in fact, which states that there is no statute of limitation on prosecution of these four crimes. And I would like to add the crime of aggression, which one day we'll be able to speak to. Justice is held in abeyance, so that the warlord does not continue to kill innocent people. You pursue peace building, right? Because if you don't have peace, you have violent conflict, and if you have violent conflict, you have human beings that are dying. That's my primary concern, in case, again, I'm misunderstood here. So justice can be pursued, even through the ICC, at a later stage. In fact, you could use that as a tool of leverage with these warlords, right? And I think that goes to the heart of the lack of understanding, really, between this nexus between peace building and the ICL, ICJ. And I would like to see a little bit more understanding actually come from the legal fraternity. South Africa is an example. Mandela did not prosecute the apartheid masterminds. The leaders of the National Party and the apartheid generals are still living in comfortable Cape Town, Johannesburg, Durban, right? Because of that was the decision at that time, to lay the foundations for peace building in South Africa. But justice can still be pursued, and it's being pursued now by the Anti-Racism Forum against the FW de Klerk. So South Africa, if we agree that South Africa is a model, we have to look at it then much more carefully and not just simply dismiss the notion that justice is sacrificed. Justice is central to our core as human beings.
Well, thank you very much. So the only thing standing between yourselves and lunch is obviously joining me in thanking this fantastic panel for their comments today. Thank you.